Thank you. That again. Thank you, everybody. Welcome. Good morning, and thank you so much for joining us today. I wanted to give a little background as to how this came about, because Leticia and I were working on a client on a closing, and throughout the process of getting her to the closing table, there were certain things that were not disclosed by the other agent, as far as them needing to be under contract for a purchase versus just finding suitable housing, which delayed our closing on our end. And there was certain things that my client had to do upfront in order to be able to get to the closing table that at one point we didn't think we were going to end up closing, not my client's fault, but because of the stuff that was not disclosed by the other side. It worked out at the end because, of course, we have an amazing lawyer. Leticia she went above and beyond for my client. And at the end of the day, we did get to the closing table, but it was a learning curve, right? Some of you may know, a lot of you may not know. I was a realtor back in 2005, went through the crash, left it, but I came back freshly after the after COVID. So things are a lot different. Contracts are a lot different, just processes are a lot different. And I thought that this would be something that we can bring to you guys, whether you've been in the business for over 10 years, 20 years, or if you're brand new. I think that this is something that is important to go over. So Leticia, if you want to go ahead.
Okay, so that's a perfect lead up into what I wanted to go over with everyone during this presentation. So the backdrop was really important because aside from what she had mentioned, I had added to that discussion that I have been finding a number of other issues, not just failure to disclose certain things, but just people new to the business who just may not know how to properly structure certain terms and contingencies, or just even know what to expect when there is something that is out of the ordinary. Most of us, most people in the business kind of just see this as a from A to Z type of a situation. And sometimes it just isn't linear in that way. And we have some things that take us off track and we have to really pivot and try to get everything back on track. But the discussion that I wanted to bring to you today was centered around these pitfalls, things that are just happening because we may not be setting them up for success, and what we can do more positively, what can we do to really set them up for success? So that is where we have our title and what we're going to be discussing today. Okay, so just a little bit of background. My name is attorney Leticia Crespo. I've been working in this industry for now coming on my 22nd year with my office. I'm a bilingual attorney, but we can move on from it because just want to make sure that you have a framework for someone that is full-time in this business. This is what I do all day in my team. It's not like I'm what I like to call the dabblers in the business, because it really does make a difference when you are trying to keep things on track and you have folks who are sidetracked because their priorities are into other markets or other areas of practice. And that does have an impact when on the other side, I am now up against, let's say, any of the issues that we are going to explore. It has an impact on how those solutions are received or some of the pushback that we get. So basically just kind of, in addition to diving deep into this, I really think it's important to have this discussion because I think this is the most important part, right? Because we know that you're all putting in so much effort and you're the backbone of all of this, right? I'm a part of it. We're part of a team, but you are the backbone of this entire transaction. You really put the most work into all of this, and then we're kind of really trying to supplement what you do. So keeping that in mind, my goal is always to make sure that your hard work, your effort, your sacrifices are not derailed by someone outside of what we're working with, but are always going to be part of that team. So the goal at the end of this presentation is really to just go into exploring some of the things that you can do to make sure that you can almost I don't want to say take over, but command control of your transaction, right? And aside from all of that, because we do have the client, so you're doing all the work, but at the end of the day, it's trying to make sure that as much as we can prevent the client from having a negative closing experience, that's the goal, right? Because we know that we don't know where your next client is going to come from, but typically it's within your sphere of contacts or influence. So it's important to make sure that they leave this transaction with a great experience versus saying, why didn't you know that? Why didn't you warn me of that? Or why didn't you think that many steps ahead of what could have occurred? So that's just the backdrop of kind of where I'm going to go into this. Okay. So basically, what are delaying our closings besides a clear to close? We all know the lifeline and the timeline for a transaction, and we know how you're putting it together. We're waiting for that clear to close, and we have that buzzword. But these are the 6 things that I'm finding that are becoming the barriers, right? Number 1 is choosing and setting the dates realistically, the inspection contingency, Hubbard clauses that may or may not be included. In my opinion, many times they're very weak. Understanding title and municipal contingencies and possible defects, but also the absence of these, because it's not just the presence of them, but it's the absence of them. Okay. And the next one being probate contingencies, and the last being delays and penalties versus rate lock issues. So I'm going to go into these in order. And again, if there's any point at which I will obviously open up to the question part, if you would like to ask along the way, I'd rather do them as we're in each one of them, and I'll be mindful of the time. Okay. That we have, and we need to be able to move on to some of them. Okay, so my first point is, why are we doing this in an open forum, right? That my relationship as to this topic began with Keller Williams, with Lucy and the Valerie King team, but the discussion was, well, let's make this open to everyone. Why? Because we know that this is a team-based thing, right? So we're comprised of so many different people. So that being said, I can go through this part, and now we have someone on the other side who isn't familiar, isn't being trained properly, or is just, needs to have some exposure to some of these things. And maybe the goal would be to kind of change some of the tone and what's happening around our transactions by education, right? So that's the goal. So from the listing side, I just want to make sure that we're talking about making sure you're vetting your clients properly and making sure there's certain conversations that you're having, and thinking about what may be missing from your listing appointment questionnaire. Now, if anyone knows me or has worked with me, you'll see that you're kind of going to know that a lot of things I do are very streamlined, very much so task-based, very much so list and checklist-based, right? Because it really keeps the transaction on track, because it is a transaction. We should have a timeline for the way in and the way out. So I have mine, and I would imagine and hope that you have yours. And if you don't, these are the things that I want you to think about. What may be missing from what you have, or do you even have one? So we're going to talk about what could be missing from those questionnaires. On the other side, it's again, on the listing side, are you vetting the information properly? Are you listening, active listening to your appointments to make sure that you're looking for buzzwords that are being used? And we'll get into each of those, but basically also asking specific questions that lead the client to being transparent, right? Because some of the discussions that we're having are very difficult topics that we're going to go into. Obviously, some of them surround death, some of them surround their financial distress. So most people don't want to kind of get into those discussions because it is difficult to enter them. But if you do that with a lot of care and knowledge and how you're trying to extract that information so that you can have a great appointment and disclose properly and move this towards closing. Okay, so the first one is about choosing dates to set your expectations, right? We know that this market is a little strange, right? We've been through seen some wild cycles. Having been doing this with some of the colleagues on here, we've been doing this for a pretty long time. So I feel I can honestly say I've been through 3 different odd cycles, right? 4, right? Peaking really high, collapsing, we're coming right back up, and then now being in this strange zone, right? So where there's this aggressive market, offers are what they are. So I'm not going to preach to the choir, you know what that is. But with that being said, what on the impact side, what we are finding is that we have some clients realtors who are putting together contracts for the sake of getting something accepted. And what's becoming is that these dates are just being pulled out of nowhere. So I'm asking that you really keep in mind having an open dialogue with your loan officers and ask them just up front, what are the timelines that you really think that we should be using in any offer that we present? If it's a FHA, if it's conventional, is it 30 days? Is it 45 days? But putting these deals together and setting up a contract for 2 weeks, knowing that you're just not going to be able to hit that mark, it's just literally setting yourself up for failure. And especially the client, right? Because we have to think about that and that client at the end when I'm getting the phone call saying, but they were supposed to close in 2 weeks, right? And just feeling that they're lost in that translation, and I have to take it back and say, listen, that's just not how this works. It is not that way. We have to wait on a clear to close, and this is where we are, and we have to get a clear to close. So that being said, that's really important. Aside from that, with the dates, so that's obviously for the closing date and for the mortgage contingency date. Now, when you're using your realtor contracts, for me, it's really important to make sure that you are getting these contracts over to the attorney of your choice as soon as possible. If you're using the MLS standard board of realtor contract, you know that there's an attorney review period. I know that everyone is busy. We're all doing our best, but there are limitations that everybody should be aware of. Sometimes it's the fine print. I'm finding that some folks just don't even realize that we need to have that within the 5 days of the 5 business days of seller execution in order to exercise the client's right to terminate if we have to, for whatever reason. I literally do sit down with your contract. I do review that contract. I log all of your dates. I log your title municipal. I log your inspection and the attorney review period so that I can engage your client right away within that 5 days and make sure that we're having discussions and that we're all on the same page and they have a very clear understanding of what they signed so that we're all ready to go and have the expectations set properly, right? Because I think we can all handle some sidetracks and things that may not be perfect along the way, but I like to set expectations up reasonably, let the client know that they may not hit that mark. And I always say this is actually a moving target unless it says its time is of the essence, okay? So if anyone has anything to ask on that point before I move on to the next tile.
I will. So one of my questions is because this has happened to me before, where the client tells us that they're going to go with one attorney, and then kind of like a week later or a few weeks later, they decide that they want to switch attorneys. Is that a big issue when you're starting over with a different attorney? How does that go? Because some of the contingencies have already been met as far as like the deposit and then, inspections. Can you elaborate a little bit on that, please?
So, I mean, once it's until it gets to the attorney and the attorney is engaged, really limited, right? So there's not much that we can do. I, out of an abundance of caution, tend to just, will let you know and extend until, since I've already received the file, and usually there's that dialogue. But really, to me, more importantly, is making sure that you go back and from the beginning and kind of keep stressing the fact that they need to engage and have their attorney on record, right? Like that should be task number one, along with everything else. Like, do you have your list of appraisers and everything, the loan officer, who they're going to work with, but the vetting that attorney early on in your transaction, because they need to know how urgent this is, and at least let them know that if you don't do this, you have to know that if there for any reason that time frame something happens, we got it wrong, then we're not going to be able to help get you out. Now, in the interest of time, one of the things that you can do is always just add the verbiage subject to attorney review within X number of days as well. So you can kind of expand upon that. It's attorney review period, but you can also say contract subject to review or subject to formal review or preparation of a formal contract. So you can kind of try to weasel a couple of things in there. I don't want to use the word weasel, but you may need to, if you find that you're going to gauge your client and see that they may not be, we can gauge, right? We know people who are just on it, and then we know the clients who are just not, right? And then you can kind of plan accordingly, but that's using your professional judgment, in my opinion. But if it doesn't happen, they need to just know the impact of that, right? Because they could just have lapsed certain dates. But in the meantime, until they do, you need to do this. You need to protect those dates and extend that. And if you don't have the verbiage, speak to the attorney that you work with and just say, hey, do you have any boilerplate language that we could use that if, the extension? I think I try to copy all my agents on the extension request. So you can literally take that verbiage and just have it available for yourself to extend any of the contingencies that exist in your contract until you can kind of firm up that attorney-client relationship. Okay. Anyone else before I move on?
I have one more if nobody else has a question. And you guys can raise your hands because then I'll see it and I'll be able to spotlight you. But can you also give us an example where a situation of choosing the wrong dates significantly impacted the transaction's outcome?
Yeah, absolutely. That's obvious for me. It's when you have these deals where now you have gone through, you have an aggressive agent on the other side, and you have a very firm, very personally based seller on the other side, right? Or even your own client, but let's just focus on the other side. You made a representation. They expected that you and your professional abilities vetted this information and that you just didn't randomly pull these dates just to get ahead of the line, right? You didn't want to just do it just to do that. And some people really take this personally. Some of the, it's their house and it's a relationship. It's not just a transaction for most people, right? This is their home. This is your client's home. So having a respect for that relationship means so much, because now they're just not going to trust your word. Your business integrity is going to mean a great deal. And then moving on into the future, they're going to know your name when they see you presenting an offer, and they're going to remember you, and they're going to say, this one just does these dates to get to the head of the line, and they always fall short. And then it also reflects upon the loan officer as well, because you're presenting a mortgage approval with the understanding that certain things have happened, that date has been vetted, that the loan officer is going to meet that date. Now you're also speaking to that person's business integrity as well, and their word. And now their paper, I call it their paper, right? The paper, the letterhead is worth something or it's not, right? Because we develop a reputation among people in this business. So that's where it has gone very poorly. And then if it's someone who took it personally and you don't meet your deadline, now you've spent an inspection. For me, you've given an attorney a down payment for your title and municipal search for our office. And sometimes you've already into an appraisal. So that's thousands of dollars in. So to me, that's catastrophic. And it's only because it was set up improperly. And then now you have a bad client experience, and there goes that 1 star that's on my deck, right? You see the 1 star because you're looking for them to have that that experience that's going to give you that 5-star rating versus, not, or a referral in a relationship that they really feel that everyone was dealing and operating with integrity throughout. So again, it's really putting our minds on the fact that this is not just transactional, this is relational, okay? So I'll move on to the next one. And this is where I have shared this on social media kind of as a warning, because this is where I really feel that I'm seeing the most pushback and including some litigation at this point, right? We've got clients putting down deposits and you're using buzz language just to get the offer in, just to get ahead of the game and say, listen, don't worry, take my offer. There's no, it's just as is, or the inspection is for informational purposes, right? Now, I get that. However, here's the pitfall. Here's the problem. If you have an attorney on the other side who is very litigious, right, and just doesn't realize how this all works in some respect, and they're just going to hold true to seeking clarification in the court and leverage and strong arm us in order to get a piece of your client's deposit, a portion, or all of it. Why? You go do this inspection and you come back with the results that you just don't want to move forward. Those words at the top here, those don't clarify much, right? It just says as is. As is what? As informational purposes for who and for what? So what I have created for people who are working with me is the ability to share my clause which provides clarifying language, right? Discussing the intent. So don't just use the buzzword because you think it's enough. Use the buzzwords in addition to an intent clause that says what you're trying to do. Why do I say that? If you look at your mortgage contingency, it does that, right? You'll see what it says. You'll see what the traditional inspection contingency says, right? It says, I am having this contingency for purposes of doing X action. And if I am not satisfied and I put you on notice, then you are to return my deposit if I provide such notice by such date, right? That's intent language. So if you're missing that when you create and expand upon or qualify those contingencies with this verbiage of just as is or informational purposes only, it's not helping, right? And if you're just not sure, because I know some brokerages are not fans of you kind of drafting legal language, that's fine. You can always ask the attorney that you're working for and say, hey, listen, can I just have what you think would be the best practice? Could you have that language? And then you can just add it as a writer, right? And have your own little addendum and just attach it to the contract when you send it and submit it for approval. The other thing, again, all else fails, blame the attorney. I love it. Just add us, say, subject to attorney review period by X number of dates, right? That's always an option. And like I said, I have the verbiage that I tend to use. I'm more than happy to share it, whether we work together or not. I can post it, share it with Lucy so that she can kind of disseminate that information. And I know Lewis also, as you know, for Keller Williams, they have that available because he's asked me for it already. Any questions here?
Come on, guys, this is very interactive. This is for you guys. So if you have any questions, please don't be afraid or shoot me a message and then I'll pose the question also.
Okay, so I guess I'm clear, right? Or no, there's no questions?
No, I'll ask. So with
I got a quick question.
Oh, go ahead, please.
I think my last deal, I just had the loan officer and the attorney speak early, like maybe like I guess when I put in the offer, I had them talk like the second, third day, we all spoke together and just got everything done there. Everything cleared out.
Right. Yeah, I think that's best practices, right? So that's what we're really talking about is if you don't have best practices, let's create them, because there's really just no rule book or anything like that. We kind of always have to create with an evolving market to do these things. So I think that is a great way to do that, right? That works for you. And that is, I think that's perfect, right? The earlier, the better, right? And that's why I say setting these things up, laying the foundation, relationships, engagement, conversations, really just in anything always avoids problems. There's a question in the chat that says, how many days would you say for subject to attorney review? I would say just make it aligned with your inspection. That's just an easy one, right? Stick it, because that's the first one. Well, it's the second one, right? The attorney review period is 5 business days from seller execution of the contracts or seller acceptance. But if you can kind of align that with the next one, which is, because it takes into account the relationship or the contract that your client does have to go about engaging in order to hire an inspector, right? So keeping in mind that we have schedules, it would be important to have that. So Josie also added that it is 5 business days, but not all contracts have this, right? And also keeping in mind that some of them are not going to be contracts, some of them are going to be binders, right? So that's the other issue that you could encounter, is that not all of this is all the same, right? Because people have used different forms in different areas. And obviously attorneys, we have our attorney contract. So if you feel like, I would just say this, if you're someone who is on the entry point versus someone who is very well seasoned in the business, form that relationship with the attorney that you're going to work with. And it should look like this. It should sound like discussions. It should sound like education, right? Because you're forming a business relationship. And I'd like to make sure that everyone I work with, that we're on the same page, and that if you feel stuck, ask, because I would rather do it now than end up in litigation and a bad review or a bad anything that, that could negatively impact our client's experience. So I hope that I thank you for that feedback, and I think it's a great best practice to have. And so we'll move on to Hubbard clauses, right? So this is, I'll take a step back. I believe that I finished my statement saying that it would be great if you're not sure as of as a starter agent, or you're finding yourself stuck in the mix of these things and not really sure, we can always go just create the document and say subject to attorney board or attorney bar contract. So we could go to formal contract. That way this kind of gets you in the door, and then I have a little bit more time to be able to go to formal contract. It delays the process a little bit more, but if you're starting out, I think it's worth some of the wait in order to make that happen and make sure we button up all these concerns. Okay. Next would be the Hubbard clause. Keep in mind that, you know, there is the way to weasel out of this. This is what happened in the transaction that Lucy and I had. And this is where I spent a great amount of time kind of discussing it with her, the loan officer, and just getting everyone on the same page, because, you know, everyone feels so wronged, right? We have a clear to close. Why are we not closing? They did not say that it was subject to them having to buy a home, right? It wasn't in there, right? So then the question becomes, well, Leticia, how did that happen? How can this be okay? How do they not have to pay for our rate lock issue, which that's the last tile, but they're kind of, they walk hand in hand together. So this is one of the things that it's important to keep in mind, because you really want to make sure that is it there? If you're the listing side, ask the question and don't hide it, because clearly that's what happened in the transaction that we were in, right? Whatever the fears that most people have, we already know, I think, in this business, that when we see the word Hubbard clause, I have a whole different conversation with my clients, right? I prepare them.
Sorry, just in case for anybody new that might not know what a Hubbard clause is, because I know there's some new agents. Maybe explain that real quick. Sorry.
Yeah. Yes, no worries. Thank you. So basically, looking at the first question, that's what the Hubbard clause does. It says, do you need to use any of the money from your sale in order to buy another home, right? So that clause because remember, at the end of the day, the contract for the seller, they are obligated to sell. They do not have a single contingency in a contract, none. They signed an agreement and their obligation is to sell. That's it. That's what they get, right? Every contingency in the standard boilerplate language is for the buyer. So the only time we add one for them, or there could be not only, there are some times where we have to add them, but the one we're discussing right now is when they're going to sell this house and they need to buy a home, right? And they want to make sure that they're not homeless and they're not obligated to sell the home unless they find a home, right? So that's what the Hubbard clause does. It makes sure that there's a contingency, that if they have to sell to buy and buy to sell, it is in the contract, which means that if one of those don't happen, none of them happen, right? Now, if you're not having that discussion with your client on a listing appointment, and in my opinion, asking that when you are having your conversations, when you're presenting an offer, what does your questionnaire look like? Well, we'll get into the death part, but this one is important. Does your client need to sell? Are you missing that verbiage in here on the MLS, or is it something that you need to let me know, right? Because I think it helps to build some credibility and hope that now you just know someone flat out lied to you. That's really beyond the pale, in my opinion, but at least you're asking the question, and know that, because what could happen technically is that there is a way what happened to us, right? Everybody has the ability to delay a closing, which we'll get into further, without being penalized. So we have to know that, and you can plan accordingly versus being ready to go, clear to close, contract closing date, and now you're being told, oh, we don't have a clear, right? And that could actually be that we just need to wait out what is the customary period, which we'll get into. But, you know, worst case scenario, as my client was worried in her instance, was, well, what if they don't? Well, then now we're discussing litigation, right? Because you get to sue for specific performance, because their obligation was to sell this property to you, regardless of their situation. Had they wanted a contingency, they were supposed to put it in there. But you have to wait now. Now the client is in the position of having to wait, pay a rent, you know, and the rate fluctuations and all these costs that were not part of what he or she prepares for their budget. Okay, so
that, Letty? I'm sorry. So with all of that, what happened is, and what I believe that a lot of us think covers us, is that in the MLS, it stated subject to seller finding suitable housing, right? Because that could mean many things. And that's why the confusion came at the end. They did not disclose that they specifically wanted or needed to buy and needed to close, needed our funds to buy. So that was where it was. So and we see that a lot in a lot of, because right now a lot of people are, well, where am I going to go? What if I don't find as the seller? And we take the listings and just put on the MLS subject to seller finding suitable housing. That's not enough.
And that's important just to discuss, because remember, at the bottom of that MLS, there's a 100% crystal clear disclosure and disclaimer, right? This is only for informational purposes. That does not make it part of the terms, material terms of the contract. It's not part of the contract per se. It isn't. It has to be a term, and that's why we have to have that express verbiage, right? So that's important. And again, do you have to liquidate an asset in order to buy? I think that's just another, it's not a Hubbard clause per se, but it's, kind of in the same, keep it in the same vein, where it's just this understanding that, for example, people who have to divest a 401k or some type of retirement funds, where now you're scrambling for this deposit that's now overdue. Just say it, right? Say upfront, this deposit is being liquidated, and will be forwarded upon receipt. Or in worst case scenario, just let me, the attorney, know up front. That way you're not sounding, the panic phone calls I get are serious all the time. It's like, it's going to fall apart. We're not under contract. We don't have the deposit. Well, let's say that. And the answer is, we create an addendum. I think everybody can handle the information. And if we stop letting this situation that we're in, this crisis approach to our businesses in this market, if we can kind of be a little bit more level-headed and give that guidance and kind of set the tone, I think it's helpful, right? Because now we can just say, hey, listen, my client is the second deposit is coming from here. We're just going to have an addendum extending that date. There's a solution. And most people will say, I get that, that's fine. But again, when you're like, oh, it's coming, and you're being evasive, that's a whole different situation. And people prefer transparency. Most people can handle whatever you have to say as long as you're forthright, right? So I think that that's important. The other thing that I would say is, when I see them, they are typically just poorly worded, right? And so just making sure you speak with the attorney, and it'll say just subject to this. Like, that can't be, that's so open-ended that it really shouldn't look like that. It should be about a date, because we don't want to leave your buyers in this loop of being in indefinite loop. We don't want that, right? Because what if something comes up? I want to be able to have a set date. You need to find a house by X date, close by X date, right? So if we can firm up that language, I think it would be all the better, right? And then again, we don't want to create a risk for the client's deposit, any liabilities for yourself, because you didn't include that language. Because essentially, if you can't close, that's what's going to happen. Cynthia has a question. Go ahead. Hi, Cynthia.
Hi, how are you?
Well, thank you.
Yeah, no, I was just thinking about when Lucy said, when you see seller needs to find suitable housing, you said that's not enough. That's not enough, right?
Correct.
Okay.
Yeah. You should write that into the other terms in the contract. It should be written into the actual contract that's executed.
Oh, okay. But then on the buyer side as well, I feel like when I see something like that, for some reason I always have to ask like those questions. Do you need to buy, or do you just have to find a place to rent? Or if you can find a where to go, is there a plan B? For some reason, every time I see that, that's like one of the first questions I ask right before going into it, because I want to know, if you can't find a place to go, is there a plan B? Do you have a family member? Then we decide, do you want to go into it? Like I decide, me and my clients on the buyer side, do you want to go into this if they don't have any plan B, right? So for some reason, when I see that language, it's already like, oh my God, okay, let me ask all these questions before we put an offer.
Right.
And those questions are asked And then what ends up happening is that, let's say you're the selling agent and I'm the buyer's agent. And I call you and I say, hey, you put that they need to find suitable housing. What does that mean for you guys? Oh, they just have to find a place. But you don't disclose that they have to buy and they need to use the proceeds to purchase. And then I don't put it in our contract. My buyer gets stuck in a loop because you still did not disclose that to me. Whether it wasn't at the beginning or not, we can still have a conversation all day, but if it's not put in writing and cleared out in writing, my client will be stuck in a loop like my client was.
Oh yeah, no, but I'm saying it's just like, that's one of the questions, right? It's like, do they need the money, right, to buy their next house, right? Because the reason why I ask those questions is so I know how to write on my side of the contract, right, to protect my client. Because if you need the money to buy a next house, then it's like, okay, this can go left, Mm-hmm. So yeah, there's just like things that I try to do on my side when I see something like that, seller needs to find suitable housing,
Agreed.
Yeah, that's good advice.
Yeah, those are best practices. So that's good. Like, I think that's what this is all about, right? Taking control of what we can control, knowing what some of the pitfalls, what some of the things that could come up look like, and see how to create some solutions and how we vet the information and how we do our due diligence to be able to kind of like minimize some of that. Because at the end of the day, sometimes that agent could have done that, but then there's just nothing that they can do because no one's been transparent. The client is just not transparent. Then that's just a whole different ball game, right? But hopefully that's not what we're dealing with, but that could happen. But at least we've tried everything in your wheelhouse to be able to address it. Ben also has a question. Hi, Ben.
Hi. Yeah. So, how would you handle lease back? Because there are situations where, for whatever reason, that might be something that is an option. How do you handle that?
So basically, right away, I think that those are the things that need to be brought to everyone's attention at the forefront. And I feel like the escape clause for me is always going to be, no matter what scenario you can come up with. The scenario is write it down and then say, owner use and occupancy agreement, post-closing occupancy agreement to be prepared subject to attorney review within 5, 6, 7 business days. You come up with it, because now I know what to do. I have all these documents. We have these, they're boilerplate, right? We have templates for everything, right? Everybody should, at least, right? You have them, we have them, and we have them for every scenario. Do we have to tweak them a little bit? Yes. But even in that scenario, yes, it should be there, and it should be addressed up front. When I see that, I literally will pull out I start asking the questions, right? Which is, what's the escrow? What's the amount? Because I find all of the time that people will put this in there. You put the term in there, and now we're, let's say you're 5 days out of closing. No one discussed an amount. No one disclosed an escrow amount. Right now, we try to negotiate those terms and we have no agreement, and now we can't close, and we have a clear to close. So the earlier, the better. Like I believe just being preemptive and staying on top of that all day, in order to be able to address these issues. Okay, so that's what I would say. Go have your relationship with your attorney has to be your fallback, and ask for that information. Like, hey, this is what we have. What let's get this done. Because what's the point of even getting to an appraisal or an inspection when no one is on the same page about the fact that your client wants a $5,000 escrow, your client wants $3,000 for the month, your client wants $500 a day. Like, sometimes it's just unreasonable requests, but now you're into it. You're thousands of dollars or hundreds of dollars into the transaction. So that's what I think. I think
quick question. Yeah,
yes.
Quick question regarding that. So when the seller, so let's say it's owner occupied and the seller needs, let's say it's a 2-family, right? Mm-hmm. And the seller lives in one, and then they say, oh, we need probably like 2-3 months, right, to rent. Is it better to discuss the rent amount before you have a full executed contract? Or
I do.
Uh-huh.
I don't even think there's an or. I think that the answer is yes. Because again, these are material terms, right? I think we could all agree that if you add a term to a contract and it's now a material term to the contract, and the material term is vague, you don't have an agreement in what we call the meeting of the minds. So now we have a problem with the contract, right? So if you clear, that's a material term to your client, to the contract, and it should be addressed up front. There should be no hesitation. Get it done up front. I think, Josie, did you have a question?
Comment, yeah. So for people on the call, right? So we've used, I'm part of the Valerie King team. We've used Leticia for years, really mostly since COVID, because she is someone who constantly wants to add information and make sure that you fully understand, right, as the realtor, how to best help your clients, how to protect yourself and protect your client. Not every attorney is like that. So it's super important. I don't care if it's your lender, your contractor, your attorney, make sure you're working with someone that you trust as much as possible. That's why it's important to have your own personal list of preferred kind of vendors, right? So most offices have one that they can refer to you, but if you haven't personally done business with that person, vet them first, right? Because as patient as they are with you as the agent, that's how patient they're going to be with the client. So we have another deal right now with another attorney that we did not, right? The client picked their own attorney, that's fine. She sends over an addendum for, I don't remember what it was, an extension or something, but no protections, right? And because I've been in this long enough on the transaction side, I was like, absolutely not. I was like, have the attorney look at it. And the attorney was like, yeah, it looks good. Hello. Like, so I am not a licensed attorney, but I know that this is not okay, right? The way that this was worded, and it was for a seller, right? Where the buyer was the one kind of just throwing out like generic whatever. So little things like that, like the more that you can pay attention, right? And start to, because I'm constantly work with people like Leticia who share that wealth of knowledge, right? I am able to better help clients as well. So just my spiel of just be careful who you work with.
So I'm going to move on to title municipal contingencies for now, because I know we're getting tight with the time. 15 minutes.
Leticia,
Oh, yes. Who's that?
Leticia, good morning, it's Nestor Camacho. How are you?
Hi, Nestor. ¿Cómo está? Bueno, buenos días. ¿Cómo are you?
Leticia, I have a question. A question about the lease back situation. It can work in a 2-3 family house. It might, because maybe the seller maybe can make an arrangement to use one of the units, but the other two or the other unit will be empty. And I believe that's okay for FHA, but I'm asking in a single family house, that's lease back situation is not possible, right? Because FHA would not.
So we're not talking about a lease back. Usually in those, it's not a lease because the seller doesn't lease it back. It's usually a holdover, a post-closing holdover agreement is what we're talking about, right? So they're just going to occupy the property for a certain period of time, for a certain number of days. So that usually is not the issue. It's not leasing because they're not a tenant. It's just a post-closing agreement that you're making for them. So you're holding an escrow, you're charging a per diem, and that's what they're using that period for. So I don't think that wouldn't be necessarily a lease back in that situation. But just, he mentioned it, so I'm just going to touch on that really quickly. I also didn't add it here, but please put these addendums together about tenants remaining or not remaining, right?
That's the question.
Right? Because those are the worst. When I see a contract that doesn't say someone is staying, remaining at closing, and we're talking about tenants, and then I'm at closing and seeing security deposits and rents, I have no idea. We would have no idea that there's a tenant in the house. So make sure that you're adding tenants in possession to remain, and that there is a discussion in a circulation of an addendum with that document, so that the client is clear in that they've signed that. So as to the title municipal contingencies, we're going to get into this. And I just want to, like, on the right, you'll see that the comment is important because it talks about that not everyone is really sitting on the equity that they think they are, right? Because people have this convenient amnesia when you're doing this. So when you're doing your listing appointments, this is where I'm really finding this issue come up in terms of, has the client ever been in financial distress, right? A lot of people think that just because the market is doing well and that we have some high home values, that we're getting to the title search point and we're coming up with and seeing some issues, right? Where they're just like not understanding that when they took a program, a forbearance or a deferment, that money, you have to pay the piper at some point. And they're doing that now. So they're thinking that they're going to walk away with $50,000, $60,000, $70,000 or $100,000. And then I'm like, hey, here's a $50,000 extra bill. They're like, but I didn't, what do you mean? So a lot of people, some of these banks during the first recession, so the people who were part of those distressed families that got modifications that some of you may or may not be familiar with, maybe they didn't lose their home to short sales, but they engaged and signed some modifications. A lot of people, the banks just sent people to their home with a witness and a notary, and they just signed off on things, and they thought that money just kind of went away or the bills went away. Some of them didn't realize that when they were basically getting back on track, they were exercising part of their mortgage insurance, and a HUD partial claim was being filed. So if you're not clear on that, let me know. But that's what was happening with, so some of the payoffs and title searches that we're having, the client is saying, giving you a mortgage statement, and it doesn't say the partial claim, but the title search will come in with that. So to me, asking the question, have you ever been in financial distress, right? And that could look like, did they get the COVID relief, where now they kind of have this huge deferred interest that now they're seeing that they've got to pay it, or they have that MIP, the partial claim bill that's on there, and even some of their judgment liens, because some of my closings are getting delayed because of judgment liens that are coming. So the title searches right now, they're just a disaster. Between that and open permits, they're just causing a lot of problems for me having clear to close, and I just can't close while we're trying to clarify these things. Is everyone clear on what the HUD partial claim is?
Can you elaborate a little bit on that, please?
So if most people know, when you have an FHA loan, you get mortgage insurance, and some people just think it's just an extra bill that they're going to pay. And that there's more to that, right? So when people are in distress, that mortgage insurance is covering the portion above the 80% that the client is not putting down their full 20%, right? So they only put 96.5%. Someone is covering that, bridging that gap for the lender. That mortgage insurance is what bridges that gap, so that if there's a default, they eat that first amount of money through the claim, through the insurance, and then the lender kind of gets hit at the 80% mark, right? So what's happening is that let's say the clients are in default, they're falling behind, and they basically get into a payment plan, or try to get back on track, and get reinstated in some way. The mortgage insurance, HUD, will issue the partial claim, pay that money, bring it current, but it is recorded as a mortgage on title. We see title searches where it'll be like mortgage one and then a HUD partial claim. There is no interest added to that amount. Typically, I haven't seen any. It's never really, there's no interest that I've ever seen on it, but that amount is amount that's due, and we have to request that payoff from HUD. It has the same case number, but it won't show up on the mortgage statement. It'll show up on the title search. So when you hear the buzzwords of distress, in my opinion, it is a great idea to ask them to speak with their attorney and pay for a rundown of their title. I do see that there is, my colleague is online here too as well, if you wanted to add to that. But it would be great to have that money up front, because then you have a clear to close, and then you have clients where there's, the seller is freaking out, because they're like, what do you mean I owe 10, 20, 30, 50? I've seen $50,000 of arrearage that they've paid out. Okay. And so aside from that, in terms of the title and municipal contingencies, just making sure that if it doesn't have it, add it. We have that verbiage from our formal contracts. You can just doctor that same verbiage and just add it and put it in there, because your standard realtor contract doesn't have that. There is that box that says title search, but it really doesn't genuinely provide the verbiage that we would love to see, that we see in our attorney contracts that have the title and municipal contingency, so that if there's an issue, a restriction, or a permit issue, that allows our client to kind of walk away if there's something that is major and significant that can't be remedied. So if you don't have it, add it. Then the question is always making sure that who's monitoring it. I know what I do. I monitor them all because I will not risk my license for anyone to monitor a date that's going to be of consequence, right? I'm not trying to cover anyone's deposit. So there's that. Edwin, you don't mind adding on. Thank you.
Yeah, thanks, Leticia. With respect to the partial claim, most people who have those partial claims that you're referring to don't know that they have that partial claim lien on their property. So if your client has done a modification or a loan modification, there's a high likelihood that a part of their loan was deferred to a later date. And in that case, most likely they're going to have a partial claim on there. So if your client indicates to you, or if you ask them if they ever had a modification, that is going to be a clear sign that there's probably another lien on there they don't know anything about. And the only mortgage they're seeing is the one that they're paying. It's showing them a particular number, and your numbers may be off when you're trying to give them an indication of how much they can expect to put in their pocket. So, it could become a problem for you at the table too. But the other thing I want to get back to, Leticia, is when you were talking about the tenants thing, and that's a problem for me too. A lot of times we're finding out at the last minute they're tenants. And I think people need to realize most contracts say that the property is supposed to be delivered vacant. And so I've run into situations where people have said that they were expecting the property to be vacant, and my client saying that the buyer knew that the tenants were there. Well, that's not sufficient, because what's in writing is the fact that the property is supposed to be vacant, and that's what controls. And that goes right back to what Attorney Crespo was talking about with regard to what you have on the MLS versus what you put on the contract. What you put on the contract that's in writing and signed by both parties is what controls, unless you put something specific in the contract that says pursuant to the MLS. And that's the only time that might cover you. That's
Right.
all I had to add.
Yeah, and Ed, can you just give a brief kind of introduction of who you are, just in case if people who are here, I'm pretty sure they know you, but anyone who will watch this on the replay so that they know who you are.
This is Ed Farrow. I'm a real estate attorney here in Bridgeport.
Thank you.
So, Leticia and I graduated together, so we've been doing this both for 22 years.
Thank you for that.
Thank you.
Question.
Sure.
I'm sorry. Quick question, Cynthia. How about so Leticia, you talked about the multifamily tenant disclosure, right? So how about when they actually say, okay, tenant 1, 2, 3, they're month to month, right? And then all of a sudden they decide to change it, during the process, they give one of the tenants like a lease.
That's a material term. I think Edwin would agree with that. Once you have the document, that becomes a material term to the contract, right? It's a rider, it's part of the contract. And then essentially you're looking at the fact that now they've altered a material term. That's why I want it in writing, and I want it signed as a rider or a addendum, right? Written up that some people go so far as to say that this is it, and that I've seen some, I want to say, I feel like it might be Century 21's scholars tends to use one that says that you're not able to engage in another lease, and you must disclose that to the buyer if you intend to do so. So that's a material. I've had that issue happen with a file, and I was able to get my client out of it, or it cost my client some money to have to cover that because she covered the gap, because they were going to rent for X, she rented for lower just to kind of cover the bills, and then she had to bridge that gap, and she was willing to do so. So as to the last time, I just want to add really quickly, because I want to move on to this one. I know we only have like 5 minutes left. But I did want to just mention that in the event that we run into any of those issues, we do try to come up with some solutions, whether it's an escrow, if it's possible, we run it up the line with our underwriters to see if we can do something and that the client will accept and the seller will accept. So we have some workarounds. But when it comes to the municipals, you have to remember that there also may be some exclusions that we have to engage in with regard to the type of title policy that we give them on their owner policy. If there's the square footage that's not covered, because it may not be a lender issue, but this is really the due diligence for our client. So there's just things to keep in mind, that we do have some solutions, but just the most we could do up front, the better. This next one is about probate approval. So I think you all have to kind of keep in mind the amount of death and losses that we have had are just ridiculous because of the pandemic. I'm starting to have many clients who engage in conservatorships or substitutions or administratrixes, that people who have gone through some major mental health issues as a result of the pandemic and a lot of death. And so a lot of you may start to find that we're dealing with a lot of the probate files and these contingencies in them, and just setting yourself up to understand how they work. I think we could do a whole seminar, and I know Keller did one recently with someone else, but just keeping in mind asking that question on your questionnaire, right? If you feel you want to go deeper, I'm sure Edwin and I could come up with something together and do a nice presentation on that, because he was in the probate journal in law school. So he's like really good at that stuff too. But just knowing whether it's involved, right? Because if you ask and understanding that you want to ask for the right things, right? Because what do we see? We have, is it involved in asking the right questions? Do you have a fiduciary certificate? Fiduciary certificate is what gives the authority and designates the capacity of the person who's signing for that estate. Right. So once you have that, that is what gives them, imagine a power of attorney. When someone is deceased, that is the power. That is what gives that person the power to sign your listing agreement and to sign this contract. So I'm having people sign contracts in their personal name. They don't disclose that they are in any acting in a fiduciary capacity. And now we're having to do addendums and have to do all these things that I should have done earlier. Again, I can't set my timeline right because now I have to start asking other questions. So then basically, I just also want to say, making sure that we're talking about this whether or not like their deed is in survivorship. Some people may know, some people may not, but it may be a good habit now that it's available online. Most of the land records are available. You can kind of just quickly pull that deed, look at the volume and page from the appeals card, from the assessor's page, and then go to that volume and page and just kind of take a look. Again, things can change after that, but at least you're trying to do some things once you hear that buzz language, because it makes the situation a little bit easier if the deed was in survivorship and someone has passed away. They still have to go through their process through probate to clear up their the title. But at least if you're dealing with something different, where if there is a will or if there is an administrator involved, at least you can set your expectations. So again, asking, is there, did they open? If they say yes, someone did pass away. And no, I'm not on the deed. Do you have a will? Did someone open, the estate? Do you have a probate attorney? What's the docket number? So getting all that information, because then I have to start to sleuth my way through it and ask the other attorney and see who knows what. And then obviously, if you know that it's probate, this is to me really simple but important, because I'm always having to go back and create an addendum to fix the name, right? So if you're fixed, there's some variations on this, but if it's just the general part where it's the estate of X person by the fiduciary in their capacity, executor, executrix, administrator, administratrix. So those are just, if everyone knows what each of those are, but those are the three general capacities that you can act as a fiduciary. And the other thing is who has the will, right? Because just because you've heard from the client that they have a will doesn't mean it has the powers to sell. The earliest you can get that will to the attorney, we can take a look at whether or not that will provides the statutory powers, because you can have a will that does not give the power to the fiduciary to sell that property, which means you have to go to court, file an application to be able to sell it and get an order. And then the last part is, once you start hearing death, start to get an idea of, hey, does everyone get along? Is everyone on the same page? If we had to get an approval from court, would everyone be willing to sign an appeal, a waiver of their rights to appeal a decision to sell? Because if we get the decision to sell and we have the waiver of the appeal period, we can close instead of waiting out the 30 or 45 extra days after the decree that comes in. So that's an extra timeline. And building, now here's the building and expectations, right? At the bottom, it says, build your expectations around that. Because if your loan officer doesn't know this and they're locking it for 15 days, 30 days, thinking that we don't have to wait out an appeal period when we know that people are not on the same page and we have to wait that out. You're looking at an additional 45, possibly 45 days. Okay. Anyone have any questions on that or comments for now?
I'm going to make a comment on that because so our client got hit with kind of all of these things in one transaction, like in her transaction.
Mhm.
And this was all on the seller side, right? So,
Right.
so we had both names on the contract because both names were also on the MLS. So when we did our offer and it got accepted, it had both the wife and the husband's name. We kept seeing that the husband was not, we were not getting the husband's signature, and we kept sending it back. We need a fully executed contract, to then find out the husband had passed away. So and that wasn't disclosed. And you know, at the end of the day, this is kind of good because it ended up having us presenting this to you guys today. But can you go over a little bit what ended up happening and how the paperwork, when you had to go through the probate, what documents they had to show us so that we can clear that part of the issue?
Yeah, so basically what it ends up looking like is that, you know, if they have, I mean, again, I don't remember which specific one it was, but, you know, if we're talking about having to go to court, where obviously if they're not signing the document, that is a red flag, right? For me, I look at the contract, I look at the disclosures, and I'm trying to, like, you know, I start to like put information together. And I would say that I'm sure Edwin does the same thing, right? We're just trying to get our bearings around the file. And obviously we're looking at missing signatures. It's a red flag, right? Because now we don't have a fully executed contract. And then once we find out if it's that someone's deceased, and it's because, you know, not that there's no, and let's say there's no survivorship. Now we're talking about needing to know, so we need to get that will as soon as possible, because the will then trigger what we do, the existence or absence of it. If there is no will, then we're looking at someone has to be, where's the fiduciary certificate? Because someone needed to be appointed by the court to be able to sign your listing agreement first off, right? Because without that legal capacity and authority, they're not even supposed to be signing that, right, to sell this property. So now you have your own problem with your broker at that point. The next one, so asking for a copy of the fiduciary certificate. I need to see that. Like if it was a power of attorney, you would be asking for it. Think of it like that, right? So once you have that, now you know that with that document that you're now able to go do a little bit further, because it usually will say, it has to say the title. If it's an administrator, it means, because typically, I don't want to say there's always that there's no will. It's sometimes I've seen an administrator, it's because there's no authority in the will to sell the property. So that just means that we're now talking about an extra layer of tasks where they have to file an application to sell with the probate court. You have a hearing. Sometimes on that document, they can waive their rights to a hearing and their rights to appeal. And then you can close if you have the waiver once the order decree comes in stating, we grant you, X person, the authority to sell this property for this price to this person. We can't close as an attorney, as a title agent. We cannot close without that document. It's just not possible, right? Because that's what it means, is the court gave them the authority to do so. So without waiting that out, and then obviously there's an appeal period that is statutory. You can't get around the fact that the law exists that we have to wait out an appeal period unless we have all heirs who are on board. We have the document, we have the template, and we always ask, can you get your clients and all the heirs at law to sign this? Counterparts, all on the same document. But if they're willing to do that, we can move forward and get this scheduled to close. I hope that answers the question.
Leticia, this has been great. I do want to kind of put it out there. If you have like a lot more to go, I put in the chat, maybe we do a part 2, or you could just roll and we'll just run a little late.
Run a little late, and this is the last part, so I'll just kind of run through it, right? And it's just really now like what happens if any of these issues come up, right? It's getting hot. So if any of these issues come up, right, now we're talking about delays and penalties versus a rate lock issue, right? Because now we have a loan officer telling us, hey, you know, the rate lock expires, So I think in the beginning, asking them like, hey, do you build in a buffer at all, if anything, right? Because if they are locking that in strictly to the contract closing date, that could be an issue, right? So at least building a couple days, because I think everybody has to realize that no matter what, everyone in a transaction has the ability to delay and not be penalized. And when I say not penalized, it's because our contracts do not call for a penalty unless it specifically provides for a penalty. So that's important to know, right? Because our clients will say, well, it wasn't me, it was the bank. Doesn't matter. That's you. Your bank is you. I am you. Your side is your side. So if you're not ready, whether you gave the bank everything, it's still your side. But they'll say, well, it's not my fault, it's the seller's fault. Well, if they need an extra couple of days and they're saying that, you didn't have a clear to close until the day before the contract closing date, and you're upset that they're not willing to close that same day, the next day, I think it's unreasonable. Yeah, it really is, because I think it's not a reasonable expectation to have that someone who you've given really no notice to, especially if you're under extension, right? If your original contingency date was 2-3 weeks before, and now I've extended it out significantly because it wasn't ready, and now it's ready in the next day, how do you think they're going to cooperate? I wouldn't pack my house until you had a clear loan, right? I'm not going to call my movers. I'm not going to move out of my house. So I think if you put yourself in the other, on the other side of it, some perspective, it was reasonable. But now we're talking about whether or not that's been built into the transaction from the client's loan side. And most of the time I have all my clients saying, I think they should pay for that. And I'm like, well, they're not responsible for paying that. So unless the only one that I see is our formal attorney contract that has a penalty clause, which I am not a fan of, because it usually starts to run 5 to 6 on the 6th business day, then from the contract closing date, that's what that one looks like. So I don't want to see that one anyway on my side, on their side, because it's pretty, it's heavy. And especially in Fairfield County, once you get out of Bridgeport, from Fairfield down to the Greenwich, that's where you're going to see it. And they'll swap out from the realtor contract to that contract just to have that one. So that's what could happen, and just keeping the expectations and just what it's going to cost, like having those discussions, and realizing that generally speaking, unless if it's the bar contract, Edwin, we could agree that it's 4 weeks from the contract closing date. That's when you're technically in breach. The regular, without the realtor contracts you guys use, it's not specific, so they're going to kind of look to case law on that issue. Okay, Edwin has a comment, and then I think we're done. I'm done.
No, thanks for bringing that up, attorney. I just wanted to co-sign what you're saying about those things. The other thing I want to just add to this conversation that's happened way too often in my practice is, and that is resist the urge. If you're on the buyer side of the transaction and you're under a lot of pressure, we've asked for 1,000 contingency extensions or mortgage contingency extensions, resist the urge to tell the seller side that we're clear to close. Do not do that unless you've talked to the attorney, because all too often we've been in situations where the lender's indicating to you that the file is clear to close, and in fact it is not. And then the agent communicates to the seller side that it's clear to close. You've pretty much put us in a position where our client has waived their mortgage contingency. And if that thing goes south, and it has happened, now we have to figure out how to fight and get that deposit back if this thing doesn't close. And so I'm just putting that caveat out there. Do not, even if you've heard it directly from the lender, do not tell the other side that without consulting with the attorney first. So that's just the cherry on the top. I just wanted to add that to protect you and your clients.
Right. I think that I'll add to that really that boils down to, once you start throwing and wielding that language around, you're compromising our ability to protect the mortgage contingency, right? So once you start to say those things, you're almost kind of usurping our ability to say we need to cancel because we don't have a clear to close. Right. So you just want to make sure that you don't kind of run yourself into that situation, because it's going to cost you. And I know Edwin and I, we always end up having to backtrack and say, and it'll be in caps, this is not, you did not hear that from me. It is not, I reserve this contingency. So I have to kind of go back and qualify that statement. And again, it's still adding to work, right? Because we all know how much time we pour into our businesses, into a file, and we calibrate our fees and costs because we really know what it takes to get a deal done. But once they start to get really complicated, we do try to keep it so that it's not cost prohibitive. But once we start getting these really complicated deals, you know, that's not built into this, but if we could be mindful of creating transactions with the least amount of chaos, with the best expectation set, I think it leads everyone to a successful closing. And that's just kind of how I will leave it. If anyone has feedback and would like to kind of go deeper into any of the topics, I'm sure Edwin and I can find a way to do so. But I think that this really covers the superficial pieces. There was just one comment that I just will get to, and that was in the chat about how to best frame when there are multiple, someone I guess is on the loan, but they're married or not, but just getting them on there. I would just say that leaving the main contract verbiage as one person, like the buyer, and then in the notes, that's where you can say title, however, title will be held or vested in the name of Mary and Joseph, let's just say, right? Because the contract header can still say Mary, but the title you would write in the note that it would be vested in that. If not, if we get to it, then we just have to do an addendum, because that's always the phone call, right? Like this, the husband is like, my wife's going to kill me if I don't show up on here. My husband is going to be so upset because he's not on the deed. What can we do? Unless I have authority from the lender, I am not going to do it. So that's that. Any other questions?
I have one real quick. It's just very fast.
Yeah.
Leticia, who is really responsible for the contingency dates, the realtor or the attorney?
Well, we
Extensions too, I'm sorry.
For inspections.
No, extensions, when you have to extend the date.
We don't handle the inspection contingency because we don't navigate that. We don't schedule it. You're the one who's protecting it. You're negotiating your deposits, and you know the deal on all those things. And that is the response of that. We are clear on our fee agreement that we are not monitoring that, right? So you, as the person, asking and liaising between the inspection and the inspector and the client, and even the lender, to let them know that it's satisfied, so that they can now go forward with their appraisal.
Actually, it was not inspection. I wouldn't say the contingency, mortgage contingencies.
Well, the mortgage contingency, you have to, it depends, right? Like like I said, for me, and I know for Edwin, so the reason I do it and other counties are different, and you need to set that expectation up front. Who is going to be responsible for it, right? Because think about it this, you gave a custody of that contract over to the attorney, right? Mm-hmm. And there's dates that are critical. There should be an understanding based on a conversation what that looks like. Everybody who works with me knows I am going to extend the mortgage. You don't have to ask me if I did it. I did it, right? The closing and the title and the municipal. And anything else, like if there's a Hubbard or anything like that, any contingency like that outside of the inspection contingency, I'm going to do that, right? And I do that only because the deposit, I won't run the risk. At the end of the day, if someone misses that date, 20,000, 50,000, 3,000, 1,000, I don't care how many dollars it is. Our clients work really hard for that money. Now, if they feel that someone and their team, all of us, didn't get that done, they're coming after us, right? We all have malpractice insurance, and I don't want to deal with a claim. Haven't had one in 22 years, and I don't intend to have one moving forward. So I have alarms. Anyone who knows me, if you call me at 4 o'clock, don't talk to me, because I'm not going to pick up. I have an alarm that goes off at 4:10, one at 4:30, and one at 4:45 to make sure that I'm starting to knock those out on my list, because I leave that as just like I don't want to answer to the grievance committee. I don't want to answer to the client that we lost their money because we didn't extend. That's just not acceptable for me. However, you will see that in other counties, the attorneys don't do it. And I personally I don't want to be mean, but I don't care. I'm still going to do it. They'll say, the attorney on the other side will say, well, we don't handle that. We leave that to realtors. I am not going to leave my license or a $10,000 deposit to anyone. No offense, but I'm not doing it. So I will do it regardless. If you want to do something to supplement and mirror mine with your own addendum through the realtor, great. But you will see that I'm going to send it out. But that is about your relationship building and the expectations of who you're working with so that they know and you know who is going to do what. This is a significant purchase. I had a client who told me, thought he had to remind me that he is not buying a bag of apples the other day. I know it's not a bag of apples. And that is why I'm really treating it really, really seriously, right? Because it's not a bag of apples. This is their hard-earned money. So for me, it's that critical to make sure that everyone on my team knows who's doing what. And no matter what, at the end of the day, for me, it's at the end of the day. For some folks, it's at the beginning of the day, but it has to get done and get out before 5:30. I try to do it before 5 because some people who don't understand the business think that it's like 5 o'clock and it's not. But because I don't want to have that argument with people who don't get it, I just get them out before 5. Edwin, you want to add to that?
No, I agree with you 100%. And to your point, depending on what county you're in, you just, as the reasonableness standard, you need to understand the customs of that particular county if you're going to do business in them. And I know in New Haven County, for any of you who do business in New Haven, the agents do virtually everything in New Haven County except do the closing. And a lot of times they do all the mortgage contingency extension request and inspection contingency request and everything else. And even when I'm working with them, I, like Leticia, I do my own because I'm not leaving it up to the real estate agent to take on that responsibility, because at the end of the day, I know the client's going to look back at me and say, you were supposed to protect me. And I've seen them go bad. And so I agree with Leticia.
Yep. All right. So I think we're good to go. Right.
I just want to take the time to thank you all for joining us today. This was truly something that Leticia and I spent a lot of time on because we were going through it. It was a lot of things that I had to learn, that I had to go back and explain to my client also. And we just wanted to make sure that we shared it. And if you guys have like any other questions or topics that you guys are running into that maybe we can put something together for you guys, please reach out. Most of you know my number. If you don't have my number, it's 203-535-5489, 203-535-5489, or you can reach any one of us, Josie, even Leticia directly, but just let us know because this was really important, and we hope that you guys got something out of this today. Also, we will have the recording. I know we're going to share it in our YouTube channel. We're going to share it through Keller Williams also, and anyone who is not in Keller Williams, we will find a way to get the link to you guys. So that
I'll make sure Leticia gets a copy.
Yep. And also I'll also share my deck.
Okay, yes, we'll share the slides. So we'll get all this information for you guys.
All right. Thank you, everyone. Appreciate your time. Have a great day.
Thanks, Leticia. Great job, ladies.
Anytime.
Thanks,
Bye.
Crespo.
Bye.
Thank you.
You're welcome.
Thank you so much.